during COVID. She quit, which considered constructive termination, because if you quit because you really have no other choice, it's kind of the same as if they fired you. I mean, every client who sues a big company kind of wants to walk away with $1 million.
Welcome to Just Settled. On today's episode, we have with us an incredible attorney out of New York, Janelle Romero, the Managing Associate of Consumer Attorneys PLC. You are a labor and employment lawyer. Janelle, thank you so much for joining Just Settled today.
Yeah, thanks for having me.
Yeah, and this is a very interesting case. We haven't covered anything exactly like this, what we were discussing before, so I just kind of wanted to dive right in. Can you give like the 30,000 foot overview, just sort of what this case was, how you first learned about it, how it came across your desk, and your first kind of thoughts when you heard the details?
Yeah, it was a pregnancy discrimination case where essentially she was a nurse who was pregnant during COVID. And
Okay.
for pretty obvious reasons, it was not advised that she go into work in
Of course.
person. A lot of the work that she had been doing during the early stages of COVID, she had been working completely remotely. So, um, I don't really know like the details of exactly how she was working, but I assume a lot of it was like telehealth and paperwork related. Um, then further down the line, they started requesting that a lot of those employees start returning back to the hospital. And she had received doctor's notes basically saying that she was pregnant. And so it was very high risk for her to return to the workplace. So they requested that she continue to work remotely. So with accommodation cases or disability cases, which pregnancy kind of falls under, as long as it's something reasonable, the company is kind of under an obligation to oblige that request, especially when you have a doctor's note. Because of the fact that she had already been doing the job remotely, it doesn't really put the hospital in a good position to say, no, sorry, it's impossible for you to keep working remotely. So part of, I guess, the struggle in what led to our settlement was the fact that while they refused to accommodate her completely, they kind of tried to give her this schedule where it was like, okay, for the first X amount of time, you can work remotely 3 days a week. Then after that, 2 days a week, and then 1 day, and kind of to phase her back in.
Right.
That's not really an accommodation, because whether she's in the office 1 day a week or, 4 days a week, she's still in the office at risk. So, so we sued for refusal to accommodate her based on her pregnancy. She quit, which considered constructive termination, because if you quit because you really have no other choice, it's kind of the same as if they fired you.
Right.
So that's what led to our case.
What were your clients' expectations in terms of restitution, or how did they sort of want this case to go? What was I guess, I know that's confidential to speak about actual outcome, but what was the ballpark idea of like what a case like this looks like in terms of value?
Yeah, so it really depends. I mean, every client who sues a big company kind of wants to walk away with $1 million. We kind of have to talk them off that ledge a little bit and explain some things, which is fair. I mean, my client had to sign a confidentiality agreement, so did I. So there really is no way to know the ballpark number of how these cases settle unless you're actively seeing them settle. So I understand why that expectation kind of comes about. We typically start with very high demand numbers because we want to allow for flexibility in those negotiations. Um, so, I mean, our initial demand definitely wasn't $1 million, but it was pretty high up there. Also, my client had seen someone for mental health, for emotional distress, which
Yeah.
also allows us a much greater amount that we can try to settle for in terms of establishing that there was a severe level of emotional distress that led to needing medical attention for it. Um, so, I mean, ultimately, we did settle above 6 figures, which my client was very happy with. But I think, when you compare like the initial expectation to what the settlement is in the end, they usually don't match up very well.
Yeah.
Um, I remember like the first mediation I ever went on, a mediator said the best mediation ends where nobody's happy. The client's taking less money than they wanted, and the defendant is paying more than they wanted. And so I think that we were able to reach something sort of in that range.
Okay. Yeah, I've heard that phrase before too. That's funny that you bring that up. The nobody being happy, maybe
Yeah.
that sort of goal of mediation almost. Um, you kind of touched on this before, but in terms of like typical opposition and obstacles that you encountered, I'm sure there's always sort of things that come up a lot in these kinds of employment cases. What were some of those just that anyone that's going into an employment related case can expect? And you mentioned the hospital being big as sort of a unique challenge. Were there any kind of curveballs or things that you didn't see coming from the beginning that happened throughout the case that kind of, shifted how you had to kind of approach things?
Um, Not necessarily. I really try to make sure that I get as big of a picture as possible from the start of my cases. So I tell my clients like the good, the bad, the ugly. I want to see all of it. I want to see all the
Mm-hmm.
evidence you have. I want to see every text message you've ever sent that has anything to do with this. If you don't want to look through it, give me your phone. We'll look through your last 4 years of text messages and see what we find. Because I really don't like to get those curveballs halfway into the case and you find
Yeah.
out there was this big other variable. So thankfully that wasn't really the case here, or really in most of my cases. Um, with the hospital though, I was pleasantly surprised that pretty much, well, in the beginning, they really did try to fight us. So first we have to go to the EEOC before we can file directly in court. And in the
Mm-hmm.
EEOC, you do kind of have the ability to go back and forth a little bit and maybe even try to resolve. And they were pretty adamant that they denied everything and they weren't gonna, try to settle with us. Once we filed, they were much more interested in trying to reach a resolution. I think also because around that time, hospitals didn't really want to be, especially in New York, they didn't really want any type of negative press
Yeah.
surround how they were treating their workers or anything like that. There were a lot of strikes going on. Um, and so I think that may have been a motivating factor on their part to kind of try to get this quieted as quickly as possible.
Yeah.
Um, but I mean, it's not really a rare thing, unfortunately. So
Yeah. In terms of timeline and how long this entire case ran, what did that look like from start to finish?
it took about a year.
Okay.
We spent a decent amount of time in the EEOC. Um, I don't know if this is still accurate, but I remember at that time I was told that in the EEOC for all of New York City, they had about 5 investigators. Um,
Hmm.
so things were incredibly backed up. It took a very long time to get an investigator assigned and then to, get each step moving. And so we spent quite a bit of time in the EEOC. And then I think we went pretty much on a standard court timeline. A lot of discrimination cases get automatically referred to mediation before you really get deep into that litigation process, just to see if there's a possibility of resolution early on. And so thankfully we were able to resolve at that point. So even though it was a relatively quick settlement, it still took about a year because of that whole process.
Yeah. A year is pretty fast, honestly, from everything that I usually hear. That's pretty quick turnaround. At what point did you know, or did you kind of sense that a settlement was likely, as opposed to this going all the way into court and in front of a judge and everything like that? Like, when did you kind of know they're gonna settle on this?
I had a pretty good idea from the start, because I was very confident in our case. I was very
Hmm.
confident in our claims. I had seen all the evidence my client had. She was very diligent about making her complaints to HR about discrimination. She always submitted her doctor's notes. So, and she was also, very educated, very good witness. So I knew that if we got to trial, it was likely not going to be a good outcome for them, especially around the time of COVID. Like, if we're going before a jury and saying, here's this nurse who worked all of COVID, now she's pregnant, you guys aren't treating her very well,
Right.
probably wasn't going to be the best outcome for the hospital. So I had a pretty good idea from the start that they probably weren't going to fight us till the end. It was just a matter of how deep in that process were they going to make us go before we got to that resolution.
Yeah, and I kind of want to dive into that a little bit in terms of just the negotiation component of this. I know that defendants, in this case, a hospital, always tries to minimize compensation or accountability, and kind of like that's to your point before of why you come in with a high demand, right? You know they're going to lowball. Um, how did you advocate for your client's interests in this case?
I think a good lawyer is very stubborn. And so in our mediation, the mediator kind of goes back and forth, making one side's points to the other. And they really kept sticking to the fact that they tried to accommodate her.
Hmm.
And I was very adamant in the fact that trying to accommodate her in a situation where you absolutely can doesn't count as accommodating her. The law doesn't say like you have to try and see. It says you either can do it or you can't. And it was
Hmm.
very clear that they could. And so, obviously every mediation starts with very low ball numbers. Um, but it's really kind of like a battle of the wills to see how far each side is willing to go. And I had prepared my client, as I always do, that we might not settle today. We might just walk away from this if they don't reach a number that we're willing to accept. So, with that in mind, and with the other side understanding that, I think that they were much more motivated to make some bigger jumps in our negotiations than I think would typically be expected, when you're starting with, the typical super low numbers that they start with.
Yeah, and I know this is a confidential. You mentioned over six figures, but in terms of what that outcome ended up being, can you kind of speak to just how that did positively impact your client, and how they kind of came out? As you mentioned that she quit the job, I think, but it was sort of almost like a forced termination because she had really no other option. How did this settlement and kind of getting that closure help her just move forward?
Yeah, I mean, a big thing with discrimination and harassment cases is that no amount of money is going to undo what happened or any type of
Hmm.
emotional trauma that you went through in this situation, especially like a sexual harassment case. The idea is that the money helps you move on. So, she was able to spend some more time than she had planned at home with her child before having to, look for other work. I don't necessarily know what else she did with the money exactly, but I know that it provided her and her family a little more relief in terms of the timeline of what she had to do next with a newborn or an infant at home.
Yeah.
So I think that it just provides a little bit of cushion and relief into what you have to do to kind of move on with your life next, because it's not really the type of case where, like, we have cases where employees aren't paid properly, we get them their money back, now your problem solved. But when they're more emotionally charged, it's kind of hard to say that we really fixed their problem. We just kind of gave them a little bit of a bridge to cross over into whatever's coming next.
Yeah, that's a good way to put it. Well, Janelle, thank you so much for sharing this case with us today. We learned a lot. Again, for anyone listening, Janelle Romero, Managing Associate at Consumer Attorneys PLC in New York. For any labor and employment issues, definitely reach out to Janelle. Janelle, can you just tell our audience where they can find you?
Yeah, we have a website, consumerattorneys.com. I'm also on TikTok at Janelle_RB.
Awesome. Well, thank you so much for being on Just Settle today. And yeah, we hope to have you back soon.
Yeah, thank you.